So let me give you a hypothetical. State court denies testing on one ground. Party, you have taken the position in your brief that the accrual should be from that decision, correct?
Assuming that that ground is a constitutional violation, yes, Your Honor.
All right. Now, they go up on appeal, and there was no appeal there. They go up on appeal, and the appellate court in Texas says they were wrong on ground one, but they were right on an alternative ground. And now you say the plaintiff should appeal from when? He should have appealed from the first decision, or now he should appeal from the second, or both?
If I understand correctly, Your Honor, so we've got a trial court that imposed one unconstitutional condition. And
he should have appealed then, that's what you're saying.
Well, if there's, I assume because the appellate court's involved that he appealed that first judgment.
No,
are you saying that
he does, are you saying that him appealing stays the time he has to file a motion?
No, Your Honor. He can go immediately to federal court on whatever the unconstitutional
Let's assume he does what the state tells him, does a timely appeal. If he came to federal court in the middle of that appeal, would you argue that he doesn't have a viable claim yet?
No, Your Honor.
The appellate court hasn't decided this issue constitutionally.
Certainly not, Your Honor, on the assumption that his claim is that the trial court's decision included some condition that violates due process. Let's say this non-contamination.
The same as here. And so you're saying, what should the federal court do? Should it stay and wait until the appellate court says yes or no?
It need not, Your Honor. I might point out for practical purposes, for specifically Mr. Reed's claim, even had he waited past rehearing, even had he waited past certiorari being denied, he still had about 10 months left on his 2-year clock. So
I
the
know,
idea
you're claiming he was dilatory, but putting all of that aside, you still maintain that there's some practical importance to not letting him not exhaust, but go through a pending appellate process?
He may, Your Honor, if he wishes, but if he's already suffered a constitutional
And so
violation,
now the federal court should wait or not wait?
it need not, Your Honor.
But it can.
If parties request that it wait, that would be on a case-by-case basis.
Seems like an awful waste of time.
But, Your Honor, the idea that there would be a freestanding stay or freestanding essentially pause on the accrual of 1983 actions merely because there are similar topics and issue in state and federal court is exactly what this court rejected in Wallace.